Ronnie Henderson, the Second Amended Phelps Family Trust, Eric Sorensen, Jamie Sorensen, David Smeltzer, and Lindsay Smeltzer versus the Valley View Park Estates Homeowners Association, Incorporated.
Everybody make your announcement.
Caitlin Coker on behalf of the Second Amended Phelps Family Trust, Eric Sorensen, Jamie Sorensen, David Smeltzer, and Lindsay Smeltzer.
Kelly Milligan for defendant Ronnie Henderson.
Greg Fell for Francisco and Mary Ann Gonzalez.
Mr. Miller, are you here? Are you going to make an announcement or not?
Casey Myers on behalf of Valley View Park Estates.
Judge, David Welch. Mr. Miller looked like he was muted. All right.
I was muted, Your Honor. I'm here also on behalf of Mr. Zubarik.
Okay, and Mr. Welch, why don't you make your announcement?
David Welch on behalf of plaintiff. I'm just watching today, Judge.
Okay. All right, let's proceed.
I'll kick it off, Your Honor. This is a motion on behalf of the defendants, the Gonzalez defendants, Ms. Coker's clients, and Mr. Milligan's clients. I emailed 2 exhibits to the court's reporter this morning. I'd like to offer them defendants exhibit 1 and 2 into evidence at this point. They're the documents that are at issue.
Tony, do you have those? Tony?
I'm sorry, Judge. Yes, I haven't had a chance to look. I had no idea he would email them this morning. Do you need me to check real quickly? Yeah,
why don't you go ahead and check? And I haven't seen them either. You're really supposed to do it under the emergency rules the day before. So, but if there's no objection, we can deal with them.
Your Honor, they're certified copies of the declaration. I don't have an objection to that.
Okay. Do you have them, Tony?
Yes. Well, I see the email. I haven't opened it up, but yes.
And then, let's see. And Rhonda, have you, okay, so let's go ahead and proceed. I guess if there's an objection, somebody will make it. So there's no objection. So I'll go ahead and admit exhibit 1 and 2. But did you email those to Rhonda as well? Because I don't have a copy of them.
I will, Your Honor. Would you like me to do that literally right now?
Yeah, because I thought it'd be helpful. I guess you could also share a screen, but are you going to share screen the documents?
I could do it. I could certainly email right now. That'll take 1 second. I'll just forward the email I sent to the court's reporter to Rhonda. Okay, I just did that.
Okay.
I have a 30-second delay on my email, so that'll take probably about 45 seconds to get there.
No problem. Let's go ahead and proceed, okay?
Your Honor. Your Honor, this motion concerns the court's interlocutory summary judgment that was signed on October 23rd, 2020, finding that the defendant's fences were in violation of the restrictive covenants of the association. Since that time, specifically on March 24th, 2021, the members of the association voted to amend the declarations. That vote passed. The amendment, which is Defendant's Exhibit 2, was duly filed with the deed records of Dallas County, completely reversing the situation that was involved when the court made its ruling back in October. Specifically, the declaration now allows the very fences that are the subject of this lawsuit to exist in the place that they are erected. Therefore, because we have a change in circumstances since the court signed its order granting injunctive relief, in essence, we're asking the court to dissolve that injunction and vacate the order. Just to be a little proactive, I've looked at Mr. Miller's response. His argument is, number one, that there is no injunction to dissolve. And his reasoning is because there was no verified petition and no bond required. As the court knows, a verified petition and bond is only required for a TRO or a TI. Neither of those were pled for by Mr. Miller, just a permanent injunction. Which the court granted. Secondly, he says that, quote, the change in the declaration does not change the court order that attorney fees be awarded to plaintiff. That's not accurate at all. The court's order back in October says, quote, the court will consider the award of a plaintiff's reasonable and necessary attorney fees for bringing this case when plaintiff files his motion for summary judgment on attorney fees. So the court has made no determination on attorney fees at this point. But the bottom line is the circumstances that caused the court to enter injunctive relief have materially and substantially changed. There's no violation.
Can you share screen the order you want me to dissolve?
Yes.
So I can look at it.
It looks like you've disabled sharing, Your Honor.
Oh, I'm sorry. It's just automatically. I haven't enabled it yet. Okay, go ahead. Go down. Okay. Response.
Well, Your Honor, you forgot the last thing. There's currently a recount of the ballots that may change whether the amendment to the declaration was actually approved by 2/3 of the voters or 2/3 of the honors. So I would suggest that this is a rush to get something done before the recount is taken care of. And it should be postponed until the recount is done. It should be in a week or two after we've got Judge Harlan Martin is going to be the person who's recounting the ballots. And it may take him a week or so. There's like 100 people. And we think there's some real problems with the voting and that will change the outcome. And there won't be an amendment. So we think that's a real problem right now. And the fact that they amended the declaration now does not change the substance of the order that you signed, because at that time they violated the declaration. And now the fact that we cannot have them move their fences doesn't mean that they did not violate the declaration as it was when you ordered it. Now, granted, I would not bring this lawsuit now, but that's not the issue. The issue is, did they violate the declaration when you signed your order? Absolutely, they did. And there's no reason to vacate it or do anything to it because it's still there. And the fact that they managed to try and change the declaration to say they didn't do anything
Mr. Miller,
wrong.
remind me of what cause of action the summary judgment was on. Was it on a declaratory judgment cause of action, or was it on because this doesn't appear to be an injunction.
It was on a declaratory judgment to find that they had violated the declaration.
Okay.
Which they had.
Like, in specific performance at the time. Well, it's kind of an interesting point. I'm going to go ahead. So let me make clear what my ruling is here. And so when you draft the order, I want both sides to sign off on this. I am going to vacate this order to the extent that it orders the fences to be removed. I'm not vacating the order when it comes to the issue of whether or not attorney's fees may or may not be appropriate at the time of trial. And so I just want to make that clear, because I do think at the time the order was entered, you know, the appropriate remedy was a granting of the summary judgment. And there's the possibility that I could award attorney's fees at some point in the future when this case is over. So I don't want to vacate that portion of the order, but I do want to vacate the portion of the order that orders the fence to be removed. Does that make sense?
Yes, Your Honor. Understood.
Unfortunately, it does, Your Honor.
I'm sorry?
I said, unfortunately, it does.
So if you could do this, if Mr. Fell or Ms. Coker, if you can go ahead and draft the order, share it with Mr. Miller, and then make sure that you state on the order on April 19th, 2021, the court entered the following order as opposed to on this date. Share it with him, see if you guys can sign, I'll sign off on it, and then submit it to the court via email to Rhonda Pinson, my court coordinator, and to go ahead and e-file it as well. Does that make sense, guys?
Absolutely. I'd be happy to handle that.
All right.
Yes,
You guys
Your
be
Honor.
safe, okay?
Thanks, Judge.
Thank you.
Thank you, Your Honor.
Thank you.
Are we excused, Your Honor?
Uh,
Yes, so.
you are, yes. Thank you so much.
All right. Thank you.
Okay, let's go to the next hearing. Having some problems pulling this up. Okay, our next hearing, is anyone here on Gillis versus Bradley?
I'm John Gillis, and I'm the movement and represent the movements.
Okay. All right, Tony, let's go on the record on cause number DC 211266, Gillis v. Bradley. Counsel, make your appearance. Mr. Gillis, if you could state your name.
John Gillis for the movement, and I represent the other plaintiffs.
Okay, let's go ahead and proceed.
Okay, Judge, this is a lawsuit against some foreign nationals, and we're attempting service under the Hague Convention. And I have engaged the services of a foreign service professional in Oregon on the recommendation of Lee Russell, who is the process server that I use here in Dallas for a long period of time. The process server had suggested that I file this motion asking for an order from the trial court appointing them to serve the authority in Belize, where the defendants are, under the Hague Convention. And it was basically kind of a belt and suspenders position. They said that they have seen motions to challenge the service in Texas, in suits in Texas, for failure to get an order appointing. They said they have not seen one granted yet, but they asked me on their suggestion, I filed this. And their alternative was, if I don't do this, then they want something from me, a signed agreement that they'll go ahead without the order. So that's the position of the motion. And we're just asking for the order to appoint them to serve under the Hague Convention on the authority in Belize. And then Belize, as I understand it, takes over, and the judiciary there controls the service.
That's my understanding too. I've never done this. I've looked at it. I don't see a problem with it, but I've never done this before in terms of having to, I've had cases served at the Hague Convention on a few occasions, but never had this particular order, but that's fine. I'll go ahead and sign it. And hopefully we can get service. Let me just kind of look at this case real quick and see.
Oh, okay. It's a wrongful death claim.
What are you, let's see, are all the defendants foreign nationals or just some of them, or kind of what's the
There are two defendants, the driver of the car and the owner of the car, and they are both foreign nationals. One is the owner and the other was operating the, whatever they call their service down there, kind of a taxi.
Okay.
I sent a proposed order when I filed the motion.
You did. I just printed it out, and I'll go ahead and sign that, and we'll go from there. It should be signed and entered by tomorrow. By tomorrow.
Okay, fine.
All right.
That'll be great. Thank you, Judge.
Thank you. And hey, Rhonda, go ahead and have you, Mr. Gillis, have you left already? You still there?
I'm here.
So why don't we do this, Rhonda? Let's put this on a 90-day DWAP. It'll take them a while to get service. And so we're going to put you on a dismissal docket for 90 days. If you're still trying to get service, I know it takes a while under the Hague Convention. Just give me an update of where you are on the process. So we'll put it on a dismissal docket in 90 days and just be prepared to give us an update.
I have been put on alert by the lady in Oregon that the holdup will probably be in Belize. And once it's served on that central authority there, then for them to take over and serve the defendant, she said that may be where the time problems come. But I will keep you posted. Yeah,
that's all we want. Is I understand. I've never dealt with this in Belize, but I've dealt with it in a lot of European countries and in Asian countries, especially. It can take quite a while. So we just want to make sure the case is moving forward, and that if there's anything else you need and all that kind of stuff. So just kind of give us an update.
The cause of action expires when the plaintiff expires. So I'll be anxious as you to push it as quickly as I can.
Sounds good. You
at my stage in life.
Okay.
Anyway, thank you, Judge.
Mr. Gillis. You have a good day. Okay.
Thank you. Now, bye-bye.
All right. Is there anyone else here? I think everyone. Okay. Mr. Gillis, you're welcome to head out. I'll help remove you if you need it.
I'm looking for okay.
Okay. Our next hearing, I think, is at 10 o'clock. Did you guys have any questions?
I've never seen anything with the Hague Convention before.
Yeah.
Is that Texas specific, or is that a federal?
Way I understand it is each state decides whether, the Hague Convention is the general convention that America has entered into with a lot of other countries on how to do service of process. And so it's not every country is a signatory to the Hague Convention, but if they are a signatory to the Hague Convention, and apparently Belize is, I didn't know that, and the United States obviously is, then they have to follow the procedures of the Hague Convention in order to get service. It becomes significantly more difficult, not necessarily impossible, if they're not signatories to the Hague Convention. But if you ever have a foreign defendant, that's kind of the first thing you want to figure out is, are they a signatory to the Hague Convention?
Okay, cool. I've never seen that before, so that was interesting.
It's pretty uncommon. I've probably seen, in 15 years on the bench, maybe 20 times where people have dealt with the Hague Convention. So I don't see it all the time, but it does come up. It's not unusual, and I had to do it once when I was in private practice, and it just took forever. We were trying to serve someone in China, and that just took forever. So but that's how you have to do it. So you really hope that they're a signatory though, because it's difficult enough through the Hague Convention. If they're not through the Hague Convention, it's even tougher. So, but anyone else have any questions? Peyton, do you have anything? Okay. All right, guys, we'll reconvene at 10 o'clock. Okay.
Perfect.
Thank you.